What's up, guys? Dom here with Restricted America. Hope you guys are having a fantastic day. Some really good news just came out of the Massachusetts Supreme Judicial Court today. It has to do with the switchblade ban, and it pertains heavily to the Second Amendment and Supreme Court Second Amendment rulings in the past, especially Bruin and Heller. So I have an article that I'm going to read. It's by Nate Raymond, and this is Reuters. So this was Boston, August 27th. Massachusetts highest court on Tuesday struck down a state ban on carrying switchblades, saying a landmark U.S. Supreme Court ruling requiring modern gun restrictions to be consistent with the nation's history and tradition covered other weapons too. The Massachusetts Supreme Judicial Court held that a 1957 law barring people from possessing spring-release pocket knives, commonly known as switchblades, violated the right to keep and bear arms enshrined in the U.S. Constitution's Second Amendment. The court reached that conclusion while dismissing a charge filed against David Conjura, again, I apologize if I'm butchering that name, for unlawfully possessing a switchblade, which Boston police found when responding to a report of an altercation between Conjura and his girlfriend. The justice's decision was based on a 2022 U.S. Supreme Court ruling that established a new test for assessing whether modern firearm restrictions comply with the Second Amendment by requiring them to be consistent with this nation's historical tradition of firearm regulation. The ruling, New York State Rifle and Pistol Association versus Bruin, was issued by the Supreme Court 6-3 conservative majority and has led to a series of court rulings invalidating modern gun regulations. The Office of Suffolk County District Attorney Kevin Hayden, a Democrat, had argued that even after that decision, the Second Amendment's protections only extended to firearms and that knives could not legally be considered arms. 7 other states plus the District of Columbia categorically banned switchblades or other automatic knives, while 2 others imposed blade length restrictions of less than 2 inches. But Justice, I think that's Sergey? I don't know. George's wrote for the 5-0 court. 5-0 court said that the state was incorrect and that knives, like handguns, fit within the definition of arms, as both are weapons that can be used by someone for offensive or defensive purposes during a confrontation. Guys, 5-0 on one of the most liberal anti-Second Amendment courts that in the state, in the country. This is insane. The Second Amendment extends to all bearable arms and is not limited to firearms, he wrote. Georges cited the U.S. Supreme Court's 2016 decision to throw out a ruling by his court upholding a ban on stun guns. The Massachusetts Supreme Judicial Court later in 2018 said the ban violated the Second Amendment. Georges said that the state had failed to identify any laws regulating weapons akin to folding pocket knives in place at the time of the Second Amendment's ratification in 1791. Or the ratification in 1868 of the 14th Amendment, which extended the Constitution's Bill of Rights to the states. He said a review of history showed that since the colonial and Revolutionary War era, Americans had used knives for self-defense, and that the folding pocket knife played an important role both as a tool and a weapon. Accordingly, the Commonwealth has not met its burden of demonstrating a historical tradition justifying the regulation of switchblade knives, Georges wrote. Massachusetts Attorney General Andrea Joy Campbell, who we all love, obviously, a Democrat who had filed a friend of the court brief supporting the switchblade ban, in a statement called the ruling disappointing. Well, that's too bad, Andrea Campbell. Spokespeople for Hayden and Conjura's attorney had no comment. The case is Commonwealth versus Conjura, Massachusetts Supreme Judicial Court, number 6JC 13432. But guys, this is huge. The fact that the Supreme Court would cite Bruin and Heller in a pro-Second Amendment ruling, and this was 5-0. You would think that it would be razor-thin margins if something actually, came out defending the Second Amendment. And I know what you're thinking. It's switchblades, and it's knives, but switchblades, are a big deal by itself. But the way they are wording this decision is a huge deal because it's gearing up for a case with the enforcement of our assault rifle ban, or assault weapons ban. And, again, I still have my doubts that the Supreme Court of Massachusetts would rule that an assault rifle ban is, not constitutional, but this gives me a lot of hope. And this also provides huge precedent in one of those cases that, Supreme Judicial Court of Massachusetts ruled this. I also have the decision papers with me, and I got these from Goal. Mike Harris, thank you, by the way. So the important part, the whole thing's important. You can read it on mass.gov. I'm going to try to link it in the bio. So that said, we conclude switchblades are not dangerous and unusual weapons falling outside the protection of the Second Amendment. In the most basic sense, all weapons are dangerous because they are designed for the purpose of bodily assault or defense. See Caetano, 577 U.S. at 418. Alito J. concurring. As such, general dangerousness of a weapon is irrelevant where the weapon belongs to a class of arms commonly used for self-defense. CID. Consequently, spring-loaded folding knives cannot be categorically prohibited just because they are in everyday terms dangerous. At the very least, for purposes of this analysis, dangerous weapons must feature uniquely dangerous qualities that are disproportionate to their use for self-defense. So guys, this is great. Regardless of what you think about, it being about switchblades, it pertains heavily to the Second Amendment. This is going to provide a ton of precedent for any of these assault rifle cases that go even to a different court. This is going to be a good thing. So I just want to share that news with y'all. I know a lot of you have already seen this, maybe on Goal's website or just you found it on the internet, but I wanted to read all that for you and get the word out because good news has been lacking lately. So guys, if you enjoyed this video, make sure to like it. If you have any comments, put them down in the comment section, and if you're not subscribed, make sure to do that now. And I just want to add that the last video I put up, YouTube seems to be suppressing it quite a bit, so make sure to go watch it. It's I think it's titled How to Get Our Rights Back. It pertains to Massachusetts, but it could be applied to any restricted state. Other than that, guys, stay informed and stay unrestricted.